Section 550 of the Bankruptcy Code permits a court using the avoidance powers in Section 544, 546, 547, 548, and 549 to recover avoided property for the benefit of the estate, unless, and I'll paraphrase, a transfer was for value in good faith and without knowledge of the voidability of the transfer avoided. Also protected, of course, are immediate good faith transferees of the original transferees. Our focus today is on the good faith defense and whether it provides too much protection to those who don't deserve it. The Madoff case may come to mind for many of you. Our second resolution of the day is inquiry notice should play a role in the good faith transferee defense. Our second debate speakers are Catherine Steege and Philip Anker. Taking the pro side, on my right side, is Catherine Steege. Kathy is a partner with Jenner Block in Chicago and co-chairs the firm's bankruptcy litigation practice group. She represents numerous parties in complex bankruptcy litigations matters, including most recently for Wellness International Networks in its case before the Supreme Court. Kathy is the fellow at the American College of Bankruptcy and is also an adjunct professor of law at John Marshall Law School. Taking the con side, and on my left side is Philip Anker. Philip is co-chair of the Wilmer Hale's bankruptcy and financial restructuring practice in New York and has more than 20 years of experience. He has represented, it seems, pretty much every type of party in a bankruptcy case and in out-of-court workouts, and recently played leading roles in, among many other cases, Adelphia, Lyondell, and Tribune. Now, I also wanted to provide a little commentary, a little color commentary, if you will, on the speakers, as I often do, when I have insights, and I wanted to do that today because I did have some insights. I have told you in the past how serious our speakers, our debaters take their roles and prepare, and how some are just determined to win. Now, you won't be surprised to learn that these two, both co-chairs of prestigious groups at prestigious law firms and true litigators, fall into this category. It was, given that context, that it was somewhat unsurprising that one of the debaters suggested that my introduction to the other debater might include a reference to, and in fact contain certain photos from a Judge Posner case in 2011 that she suggested the debtor's position was, shall we say, illuminated by the photos. Being the fair and partial moderator I am, I of course wouldn't want to do that, but I did want to share the photos with you. So, supposedly to illustrate his position. Thanks. Kareem has put them up, apparently. Welcome you both. Kathy, we will start with you for the pro side of the debate.
Thank you, Doug. The numbers demonstrate why inquiry notice is the correct test of good faith. Each year, thousands of Americans lose their life savings to fraudsters. In 2016 alone, the website Ponzi Tracker reported that there were 59 Ponzi schemes uncovered with total losses of $2.5 billion. The 2016 numbers are not at all unusual. Since 2012, Ponzi Tracker reports that on average 65 Ponzi schemes get uncovered each year with similar volume of losses. All of these frauds typically require one thing to succeed: a bank or other key financial institution who looks the other way, protecting their own financial hides and often getting out of the scam ahead of its victims. Eliminating inquiry notice would promote this ostrich in the sand behavior, ultimately resulting in more victims and more dollars lost. Retaining inquiry notice as the test of good faith would make these financial institutions think twice about looking the other way. And it's for that reason that the majority of the circuits have adopted the good faith inquiry notice test as the test of good faith. Using the words of the Seventh Circuit in the Sentinel decision, If a reasonable law-abiding person would inquire further, then the transferee is on inquiry notice unless he can show that he made a good faith investigation and/or his inquiry would have been fruitless and he would not have uncovered the fraud. There are four primary reasons why the courts have it right. First, the courts have read the statute correctly. The only legally sound reading of the term good faith is that it has to mean something different than I didn't know the debtor was committing a fraud. And this is seen in the language of Section 550B, which imposes on a subsequent transferee both the burden of proving good faith and a lack of knowledge of the voidability of the transfer. If good faith meant only I didn't actually know there was a fraud, then the second half of that test would be meaningless. And since we assume that Congress means different things when it uses different words, the phrase good faith has to mean something different than a subjective inquiry into the transferee's actual knowledge. The second reason why inquiry notice is the correct test is that history supports that conclusion. The concept of the good faith for value defense is not a new defense. The same defense existed under the Act. And the 14th edition of Collier's, when describing this defense under the Act, described it as follows, quote, "The presence of any circumstance placing the transferee on inquiry as to the financial condition of the transferor may defeat a good faith defense unless investigation actually disclosed no reason to suspect financial embarrassment." To support its point, Collier string cites a long list of cases dating back to 1906. Congress was presumed to know what the law was when it enacted the code, and if it had wanted to change inquiry notice as the test under the good faith standard, it would have done so explicitly. By not changing it explicitly, Congress intended that inquiry notice remain a factor in the good faith analysis. Third, equating good faith with inquiry notice is the only test that makes any type of practical sense from an evidentiary point of view. Proving a party's subjective mental state is a near impossible task. Fraudsters don't leave written confessions, and transferees who are receiving property when they suspect something is amiss don't leave confessions either. So in all sorts of circumstances, when we have to prove mental state, courts look to objective facts. We don't have to look any further than the same statute, the fraudulent transfer statute, to look at the badges of fraud. These are objective facts that let us inquire into the subjective mental state of the fraudster, the debtor. In the context of criminal statutes that require knowing conduct, courts look at the objective facts, the circumstantial evidence to prove knowledge. They do it in civil fraud cases. Here, those objective facts are just what a reasonable law-abiding person would know. Allowing the subjective mental state, a defendant simply saying, "I did not know to carry the day," defies these common sense evidentiary rules. Finally, economic policy supports inquiry notice. The party receiving the transfer is in the best position to know whether it's receiving a transfer in fraud. Financial institutions are in the best place to obtain information. They write into their loan documents the right to receive financial information, audit information, inspection of their collateral, and all other types of protections. The reasons why the banks don't act is not because it's too hard or too difficult to get the information. Often what they need to know is right in their own files. Instead, they make a cost-benefit determination. They decide that the occasional judgment down the road is a small price to pay for looking the other way and continuing to make money on the fraud while it's going well, and to look the other way and get out of the scam before the other victims find out. Inquiry notice therefore places the burden exactly where it ought to be, on the transferee to investigate when the facts require it.
Philip?
Thanks, Doug, thanks, Kathy. Let me start with the law, what the law is today, and then move a little bit to policy, really what the law should be. Both support the position I'm going to articulate. I agree with my worthy adversary that when you ask the question what Congress intended, Congress is presumed to know what the law is beforehand. The term good faith is not defined in the bankruptcy code, so Congress has to be presumed to have thought it meant what it has been understood to mean in both federal and state statutes for centuries. The Uniform Commercial Code defines good faith, and I quote, as honesty in fact and the observance of reasonable commercial standards of fair dealing. The first prong there, honesty in fact, obviously focuses on the subjective intent. The second part, observance of reasonable commercial standards of fair dealing, may have some objective element to it, but it's focused on whether you, in this case the transferee, are acting fairly with your adversary, not whether you're doing inquiry into whether it is insolvent or engaged in fraud. The Uniform Fiduciaries Act, which is the principal state law addressing what fiduciaries owe, defines good faith, and I quote, "A thing is done in good faith when it is done honestly, whether it be done negligently or not." That connotes what I think everyone in this room thinks of when good faith. People whose heart is in the right place, who have good intentions, act in good faith, even if they might not have been as diligent as in retrospect some plaintiff trustee might think they should have been. Let me make a second point about the law, and it's a critical point here because I've heard the argument of my adversary. This is not about the ostrich in the sand. Those courts, in the securities law context, where securities fraud requires proof of scienter, the courts have pretty uniformly said scienter exists even if you didn't intend to defraud, if you acted with conscious avoidance, willful blindness. You were on notice and you completely ignored the reddest of red flags. So too, courts have adopted the same position in the good faith context, even those courts that have rejected inquiry notice. To quote the district court in one of the Madoff cases, in a case in which it rejected the inquiry notice standard, and I quote, "If an investor intentionally chooses to blind himself to the red flags that suggest a high probability of fraud, his willful blindness to the truth is tantamount to a lack of good faith." Now let me move to policy, requiring an even more demanding standard, that the transferee was not on any form of inquiry notice, and that it took all steps that a hypothetical reasonable person would have taken to investigate any supposed red flags, would add layers of expenses on commercial entities and banks. That would make the cost of credit more expensive. It would also burden the courts with endless litigation. As the cases repeatedly say, good faith can't be decided on a motion to dismiss. It can't be decided on summary judgment. It leads to trials, nuisance value settlements, and clogging the courts where bankruptcy courts could otherwise be spending their time focusing on helping honest debtors reorganize or obtain discharge. Moreover, it will be counterproductive to what should matter to everyone in this room. We are reorganization professionals. We know how important it is for companies experiencing financial distress to obtain credit while continuing to do business with them. If the law says that a transferee that pays fair value for what it receives nevertheless stands to lose it, simply if there's any hint that the debtor was in financial distress, creditors and counterparties will be disincentivized to deal with counterparties. It will, let me focus there on what the inquiry notice cases have said. They have said, the cases that my worthy adversary notes, that if you're an inquiry notice of either that the debtor is engaged potentially in fraud or merely that it's insolvent or in financial distress, that's enough to require you to investigate. Let me make another point, and this is a combination of law and policy. Look at the way the statute reads. To have a defense, you have to both give value and, not conjunctive, and act in good faith. So the estate is whole by the for value requirement. If I buy property from a debtor and I pay $700,000 and it turns out the debtor was the property was really worth $1 million, that $300,000 in profit I got, that the debtor overpaid, goes back to the debtor irrespective of the good faith defense. The good faith defense tells me I can lose the $700,000 that I actually gave in value. Think about what that means. What you're fundamentally saying is that a merely negligent party has to do more than make its adversary whole. It has to pay what is effectively punitive damages. There is no other area of law that does that. And there's no other area of law that puts the burden of proof, as is the case in this case. This is an affirmative defense. I have, as transferee, the burden to prove that a negative, that I was fully diligent, that I wasn't even on inquiry notice. I submit no other rule of law, no other area of law imposes that requirement, and for good reason.
Thank you, Philip. Kathy, your rebuttal?
My friend across the stage here wants us all to feel sorry for the poor banks and the supposedly prohibitive additional costs they're going to incur if they're forced to look at the facts that are right in front of their face. And there's two responses to this argument. First, who better to bear that expense? The bank receiving the fraudulent transfer, which has a commercial relationship with the debtor and access to financial information, or the debtor's other creditors who may not even know the transfer's taking place. But second, importantly, the bank is really not without a defense here. Inquiry notice is not the same as a duty to investigate under all circumstances. It requires the existence of facts that would put a reasonable law-abiding person on notice that something may be wrong. If those facts don't exist, there's no duty of inquiry and the good faith defense survives and the defendant is found adjudged not to have to return the transfer. And when the facts do exist, the bank is not required to uncover the impossible. If the bank makes an objectively reasonable inquiry and cannot uncover the fraud, the bank acts in good faith. My adversary indicates that this imposes a double recovery for the estate and is very unfair to the bank who gives the value twice. That isn't so. The Bankruptcy Code provides a remedy to protect against that double recovery, and that remedy is found in Section 502H. If, in fact, the bank would have a claim absent the transfer, 502H resurrects that claim for the defendant who must return the fraudulent transfer so that there is not a double recovery. Finally, my adversary indicates that the term good faith, as used in other statutes, does not include inquiry notice, and he points to the Uniform Fiduciaries Act. In fact, the authors of that act specifically excluded good faith, and they wouldn't have had to do that if the standard understanding of good faith did not include inquiry notice. And that's the point the 10th Circuit made in the M&L Business Machines case when it rejected that very same argument.
Thank you, Kathy. Philip?
Let me make several points. My adversary argues that in all sorts of circumstances, the law allows the proof of subjective intent or knowledge through the proof of objective facts. She's right. But the conclusion she asks you to draw from that means inquiry notice is the right standard, doesn't follow. She's mixing up apples and oranges. The question before you today is, what is the substantive standard? Is it substantively enough to defeat good faith that I had no knowledge, no conscious avoidance, no willful blindness, I just didn't do as much investigation as someone else should? Or is it that I actually had some knowledge and some ignorance of the facts? That goes to substance. How you prove it is a matter of procedure. Think about the affirmative case for fraudulent transfer, an intentional fraudulent transfer. The standard is intent to hinder, delay, or defraud, but yes, you can prove it through circumstantial evidence. That's a different question. My adversary suggests that good faith has to mean more than knowledge. Otherwise, why would 550B1 use both terms? Again, fair enough, but the conclusion doesn't follow. What that means is Congress said willful blindness, conscious avoidance defeats a finding of good faith, not that mere ordinary negligence does and provides for punitive relief. My adversary does something else that real good advocates do. You try to play on everyone's sympathy. We heard about the big bad banks and financial institutions. Well, a lot of defendants in these cases are mere transferees, and it's not good enough to be able to file a claim. Let's give a hypothetical. I invest $200,000 in the Madoff scheme. I have no knowledge of anything going wrong. I get back $50,000. Under the rule of law she's advocating, I can't get back my $150,000. I have to repay the $50,000 if the trustee can prove that I should have known something was amiss. And maybe the case pays 5 cents on the dollar, so I get $10,000 back. That is an extraordinary issue. Two last quick points. She suggests that when you get to the banks are going to simply put their head in the sands. That defies common sense. First, conscious avoidance will always defeat good faith. Second, banks are in the process of making money. At best, they're going to give up all their profit and break even. And third, this doesn't help their reputation, to say the least. Finally, on the legal definition, let me read to you from Black's Law Dictionary. Black's Law Dictionary defines good faith as something done, quote, honestly, objectively, and with no deliberate intent to defraud the other party. Yet this does not cover a sin of omission, something done or not done in negligence. That is precisely the definition of good faith I am advocating, and precisely the definition of good faith that my adversary is asking you to reject.
Thank you. Poll.abi.org. The resolution is, inquiry notice should play a role in the good faith transferee defense. Agree to no opinion. Agree. Okay, about 57% to about 42%. Thank you both.
Thank you.